Good evening, ladies and gentlemen. Tonight is the meeting number 11, and this is a discussion on the principles on wages, starting from the 15th principle up to the 21st principle. And we discussed about principles of no work, no pay, principle of equal pay for equal work, the principle of deductions, non-diminution, everything about hours of work and Book 3 of the Labor Code. I ask you therefore to join us and subscribe to my YouTube channel, which is just type USEC JBJ, and you will learn a lot from this channel. Thank you. Okay, good evening. Mayong gabi kanatong tanan. Today we will discuss principle number 15 to 21. As you will recall, last time we discussed principle 1 up to 15 on the issue of wages. So to recall, just for our recollection, the first principle was about the universal coverage of wage orders as provided by Republic Act 6727, which is otherwise known as the Wage Rationalization Act of 1989. And then the second principle was the principle of limited exceptions. The third one was the principle of no work, no pay. Especially today, and I think this will be asked in the bar examination, when we are suffering from the pandemic crisis and many companies have shortened their work week or compressed their work week, and whenever no work is available because of the crisis, the principle of no work, no pay shall apply. However, I have discussed last time the nuances and rules as well as the exceptions. We also emphasized the principle of criminal liability for violation of the minimum wage law as amended by Republic Act 8188. And concomitant with that principle is the principle of double indemnity on top of criminal liability. And also the provision that in cases of corporation, partnership, and other juridical entities, it is the executive, the chief executive officer, the general manager, the managing partner for partnership will be held liable criminally, and the imprisonment is quite longer than what you expect, no? And it is not covered by the probation law. If you are convicted of violation of Republic Act 8188 pertaining to the minimum wage law, you are not entitled to probation. Then we also discussed the principle governing the qualified barangay micro business enterprises, as they are exempted from minimum wage subject to the requirements established by law. And then we also discussed the principle on payment of wages for workers that are paid on results, Pacquiao, Takay, piece rate, boundary system, and the likes. Then the principle governing qualified apprentices and learners are to be paid only 75% of the applicable regional minimum wage. 25% would constitute as their tuition fee because they are supposed to be learning while they are earning. But for PWDs, because of the Magna Carta for person with disabilities, they are entitled to 100% of the minimum wage. As we are not allowed to discriminate against PWDs in terms of wages and other terms and conditions of employment. Then for principle number 10, we talk about tax exemption for minimum wage earners and also the ceiling amount as provided, including that of the 13-month pay. Then we discussed the equal pay for equal work, which involved the case of the International Association of Educators concerning discrimination in terms of salaries and wages. The Supreme Court declared that the act of management in the international school in giving higher salary and benefits to foreign recruited teachers was an act of discrimination. It violated the Equal Protection Clause, and it was not a valid classification because they were performing equal work, so they have to be paid equal pay. And then the principle of regulation of minimum wages and benefits, that these matters are not just subject to negotiation between the parties. The state would intervene because, as we learn, the relationship between labor and capital is not merely contractual but imbued with public interest. The state acting to protect the workers would intervene in the exercise of police power in the pursuit of social justice for the protection of the working class. Then the principle involving non-diminution of wages and benefits. We have discussed the rule and the exception, especially the case of waterfront, the Insular Hotel Davao waterfront, and also the case of Gerardo Rivera versus Espirito on CBE moratorium and the moratorium of wage increases for 10 years. And the matter as to quit claims, waivers, and releases. That is 14. The 15 is principle governing workers' preference in case of bankruptcy. I think this is our topic tonight. The first topic is discuss the law and the cases about bankruptcy of company, and this is very relevant today. If I were the bar examiner, I would ask question about this because a lot of companies in the Philippines today are suffering from financial difficulties leading to retrenchment, redundancy, and in the event that the total assets of the company would not be sufficient to answer for all the liabilities, what are the preference of credits? So we discuss this labor code provision and compare it with the civil code provision on preference of credit. No? And then we will go to the principal governing payment of separation pay, then payment of attorney's fees, the prohibition about wages, especially illegal deductions, and then the principal governing burdens of proof concerning wages. Then the 20th principle is computation of back wages, retirement pay, and separation pay. The last would be the decision of the Supreme Court in Bank in the case of Macario Nakar versus Gallery Frames, penned by Justice Diosdado Peralta, now the Chief Justice, which was decided by the Supreme Court in Bank. And this is now being used in a number of cases when cases involve monetary awards. So we will now start with principle number 15, covering the principle governing preference in case of bankruptcy. This principle, briefly stated, enunciates that when the funds or the assets of the employer are not enough to pay for all the due and demandable indebtedness like taxes, bank loans, payment for electricity, water, and other facilities, the wages and benefits of the workers, including retirement and separation pay, should command the first priority or the first preference before any other indebtedness should be paid, including taxes to the government. The original provisions of the Labor Code from 1974 up to 1989 gave the taxes higher priority than the salary and wages of the workers. But Senator Boy Herrera, an alumnus of UV Gullas Law School, was successful in passing Republic Act 6715, which gave absolute preference to workers' salaries and wages prior to payment of taxes. Can you please mute yourself, please? Because you will be disturbing the others. It is not useful to unmute yourself because you are not talking. Just for courtesy to the rest of the class, kindly mute yourselves. So, if you look at the provision of Article 110 of the Labor Code, it's very clear in the event of bankruptcy. In other words, this principle does not apply if there is no bankruptcy. So, you must be very alert when you look at a provision of the law that the preference, the order of preference concerning wages would apply only if the employer company is suffering from liquidation of its business or in the event of bankruptcy because of causes like the COVID crisis that we are facing today. So as annotated, this law was amended by Republic Act 6715 in 1989 after the Constitution of 1987 was ratified and took effect. So after the Constitution, the EDSA Revolution in 1986, then the Constitutional Commission 1987, submitted to the Filipino people, ratified overwhelmingly, and the next was Congress through Senator Boy Herrera in the Senate and Congressman Alberto Biloso of the 3rd District of Leyte. They co-authored Republic Act 6715, which, among others, amended the labor code by including a provision that give absolute preference to the workers. But the question is this really absolute preference? So, unpaid wages earned by the employees before the declaration of bankruptcy or before the judicial liquidation of the employer's business shall be given first preference. Unpaid wages. And the word wages includes separation pay and retirement benefits, because the term wages there is being presented in its generic signification. So it is not just wages, it embraces any other monetary claim, no, that may be established. So let us take a look at this case of Barayuga versus Asset Privatization Trust. No? Because you might be impulsively making conclusion that in all instances it's always the workers that will be given preference. But remember that in civil law, especially in Article 2241 and 2242, when there is a mortgage and it is on real estate, that mortgage will have a better preference when it comes to a real estate. So if the only property of the employer is a real estate, and that property has been mortgaged to the bank, and that mortgage is properly undertaken, annotated at the back of the title of the real estate property, that would be given preference over the wages. So this will now come in conflict with Article 110. So if you are asked a question in the back to reconcile between Article 110 of the Labor Code on the one hand and Articles 2241 and 2242 of the Civil Code, then you have to answer in the light of the decision of the Supreme Court in the case of Barayuga versus Asset Privatization Trust, no, which was promulgated by the Supreme Court in 2005. The court has ruled that under Articles 224 at 2241 yan and 2242, a mortgage credit is a special preferred credit that enjoys preference with reference to a specific property. So yung sa Labor Code, it refers to all the assets. So kung maraming assets ang kumpanya, merong cash sa bangko, merong real estate, yung cash, ang first preference doon ay yung mga wages talaga. But yung real estate na may mortgage, covered by a mortgage, in the case of Barayuga, this has a special preference because this is a real estate. It refers to a particular property. whereas the preference in Article 110 of the Labor Code does not have reference to a particular property. So here, the Supreme Court said that the worker's preference under Article 110 is an ordinary preferred credit, ordinary, while the Civil Code is a special preferred credit because it has reference to a particular real estate property. So, moreover, the Supreme Court said that workers' claims for unpaid wages and monetary benefits cannot be paid outside of a bankruptcy or a judicial proceedings against the employer. So, the workers should participate in the judicial proceedings. If there is liquidation proceedings before a civil court, the workers should appear, should enter their appearance so that they can line up among the many creditors running after the property of the bankrupt company. Assured thereby is an orderly determination of the preference given to creditors. So it is the bank in a proceedings before a civil court, not before the labor arbiter, but before the civil court. The creditors will line up, and insofar as that particular property is concerned, it is the bank, the creditor bank, that has special preferred credit, while the workers only have just an ordinary preferred credit. In Rubberwood versus NLRC, ito yung mga kaso na pertaining to Article 110. And these cases, walang problema dito kasi walang mortgage. Pero doon sa Barayuga, may mortgage. Here, in these cases that are now seen in your screen, it is given to the employees, the workers, having the first preference because there is no real estate mortgage involved. So the answer that you will give in the bar exam will only make a difference if there is an existing mortgage, but only insofar as the mortgage property is concerned. Now, is it possible that because of serious financial losses, there will be no more separation pay that can be paid to the workers? Well, if you have read this case of North Davao Mining, which is not a new case, but this is a leading case because this is an en-banc decision. A company named North Davao Mining Corporation is a gold mining exploration company owned by the late Manuel Elizalde Jr., the brother of Freddy Elizalde, and they were children of Don Manolo Elizalde, who used to own the Tanduay Company and many other companies, which was purchased by Mr. Lucio Tan. The original owner were the Elizaldes. And one of the son of Don Manolo was Manuel Elizalde Jr. And he has this company, North Davao Mining Company. This company became bankrupt because the rebels in Mindanao, the NPAs, always attacked the mining company and burned the equipments and the establishment to the extent that there were already no more asset to pay for the wages. At the start, when the financial difficulty was not very serious, there was an early retirement plan and people availed of their retirement. They were paid at first 1 month for every year of service, then later on only 1/2 month, and then it came to a point when there was no more money. So the question now that is asked is, because there are no more assets to talk about, is it possible that the workers will go home empty-handed? Well, surprisingly, I'm very surprised with this case. The Supreme Court said that if you read the provision of Article 283, there is a phrase there that if the closure of the company is not, take note of the phrase, not due to serious financial losses, the workers shall be paid separation pay. So it means that if the cause of the closure is serious financial losses, it is possible that the employer would be excused from payment of separation pay. So this was really the decision of the court. Excuse ang North Davao Mining from payment of separation pay. So with that, we are done with principle number 15. We will now go to principle number 16, payment of separation pay. Now, if you examine the principles, it says that separation pay should be paid based on the provision of Article 298. 298 is the new number for the old 283. So, yung mga articles ninyo sa Book 5 at saka Book 6, dagdagan ng 15. So, 283 plus 15, it's now 298. So, if it is it is separation from employment because of retrenchment or closure, and it is not due to serious financial losses, separation pay is due and demandable. And the second is installation of labor-saving device. In fact, it is the number 1. Installation of labor-saving device and redundancy. Now, the law defines redundancy as a situation where there are more people than what is needed by the company. Redundancy comes about when there is an overhiring, or there is a situation when the company has abolished certain departments or has dropped certain product lines and the need for people is lesser. For instance, originally there were one is only 600, so the choice of the 400 to let go should be based on an objective criteria which is measurable and subject to specific quantification as to the value. For instance, not just last in first out, although last in first out is unacceptable. It is acceptable. Usually company would use last in first out, LIFO, no? But that is not the only criteria. You can use other criteria. For instance, the performance rating or performance evaluation of the employee for the last 3 years, the average, and then those with the lowest performance rating, the lowest 400 would be allowed to let go. So those are the only requirements, no? Separation pay when it is redundancy and labor saving device is 1 month for every year of service. But when it comes to retrenchment and closure due to serious financial losses, the separation pay is limited to 1/2 month for every year of service. But in the case of Capital Wireless versus Secretary Nieves Confessor, the term 1/2 month for every year of service is interpreted to mean 22.5 days. How come? Why is it that in the Philippines, when you speak of 1/2 month for every year of service, it is 22.5 days, not 15 days? Well, the answer of this given by the Supreme Court in the case of Capital Wireless versus Secretary Nieves Confessor was that the 22.5 days is the result of adding 15 days plus the 5 days, which is the service incentive leave, 5 days. So 5 days plus 15 is 20. Then there is a 2.5 days, which is the result. It is the 13th month pay. It is the equivalent, the 1/12 of the 13th month pay is 2.5. So 2.5 plus 20 is 22.5. That is based on the decision in the case of Capital Wireless versus Nieves Confessor. So, actually, if you are asked under what circumstances are separation pay due and demandable, you can enumerate by saying under Article 298, formerly Article 283, there are 4. One is redundancy. Number 2 is installation of labor-saving device. Then number 3 is retrenchment. And number 4 is closure. Then you add number 5 that in cases of illegal dismissal and the worker wins the case, and therefore he is entitled to reinstatement, but reinstatement is no longer feasible, either because of strained relationship or the position has been abolished, or the person who won the case has already reached the age of 65, waiting for the decision from the NLRC, Court of Appeal, Supreme Court. It was long enough for him to reach the age of 65, so you can no longer reinstate him. That's why separation pay is paid in lieu of reinstatement. In lieu of reinstatement. Now, if there is a separation pay provided in the collective bargaining agreement or provided in the CBA or company policy that are superior to 30 days, then whatever is higher will apply. I'll give you an example. Suppose there is a company like San Miguel Corporation big companies, PLDT, Beralco, they have a retirement plan that if you have served the company for 10 years, for instance, you'll be entitled to 30 days for every year of service. If you have been there for 15 years, you will be entitled to 40 days. And then if you have been there for 20 years, you will be entitled to 2 months for every year of service. So those are superior to what is provided by the law, by the labor code. Therefore, the superior one will apply. The employees will not be entitled to both, but only to the superior one. And there is another instance. The Supreme Court, in some cases, has allowed separation pay to be given, even if there was just cause. Even if there was just cause, as long as the just cause is not serious misconduct, it does not reflect on the character of the employee, despite the fact na may kasalanan siya, pero ang kasalanan niya ay hindi naman malicious, walang bad faith, then he will be entitled to separation pay as a measure of social justice and compassionate justice. There is an example about a lady professor, a lady teacher of the international school. This is an actual case. This lady can you please mute your mic, please? Okay, thank you. As I was saying, in the case of international school, there was a lady teacher who was teaching Spanish, and she was a very good teacher. Then she was sent to Spain to undertake an advanced study in Spanish language. So she was on sabbatical leave for 1 year. When that teacher came back to the Philippines, the teaching load for Spanish has been assigned to other teachers. So she had no longer any teaching load in Spanish, and yet she was the best Spanish teacher. Now, just to give him a job, she was assigned to handle Filipino classes. She is not proficient in Filipino, and she has never tried teaching Filipino. So she had a difficulty. Kasi yan ang irony ng mga Pilipino na magaling tayo sa foreign language, magaling tayo sa English, pero sa Filipino hindi tayo marunong magbanghay. Ibanghay mo ang salitang ugat na inom sa panlapi na no? Yung uminom, umiinom, iinom, tapos lasing, no? Siya magaling sa Spanish, hindi siya marunong sa Tagalog. So, nabigyan siya ng unsatisfactory na rating. And because of that, for 3 consecutive years, she got an unsatisfactory rating. The management of international school decided to terminate her services based on analogous case, analogous to gross and habitual neglect of duty. But the Supreme Court, in the exercise of sound discretion, considering that this lady did not commit serious misconduct, the ground for the termination of her services did not reflect adversely to his character, she was given separation pay as a measure of compassionate justice. So, if you enumerate what are the instances that an employee is entitled to separation pay, number one is Article 298, redundancy. Number two, labor saving device. Number three, retrenchment. Number four, closure. Number five, reinstatement, separation pay in lieu of reinstatement. And number six, here, in the exercise of compassionate justice, when an employee is separated from her job or terminated, the employment was terminated, but the cause for the termination is in Article 297, it is just cause, but it is not serious misconduct, it is not fraud, it does not reflect on her moral character, then considering that she has been with the company for a long time, and this is the reason, this is only now that there is reason to do away with their services, then the Supreme Court gives separation pay. So there are at least 6 instances for separation pay. Now, this is a case of Romeo Villaruel versus Yu Han Guan. This is decided by Justice Peralta, and under this provision, what I stated earlier about social justice is used by the Supreme Court as a justification for the grant. Kasi tatanggalin mo ang tao, pero hindi naman siya masamang tao, hindi naman siya nagnakaw, hindi siya nag-commit ng serious misconduct. Ito yung pabaon, ito yung konsiderasyon sa mahaba niyang paninilbihan sa kumpanya. No? But if you look at the labor code, there's nothing like that in the provision of the labor code. So these are jurisprudence. No? And this sometimes when separation pay cannot be justified, the Supreme Court would use the term financial assistance. Financial assistance. And financial assistance does not have a definite measure or quantification of how much. It depends upon the discretion of the court, considering some factors like long years in service, no derogatory record, and other circumstances. The court, in the exercise of discretion, will grant or may grant this benefit. Now, if you're asked to discuss the doctrine of strained relations, well, in this case of Claudia's Kitchen versus Tanguin, decided in 2017, fairly recent case, the Supreme Court again, through Justice Mendoza, explained the meaning of the doctrine of strained relationship. Na kung ang dalawang panig ng isang relasyon ay hindi na talaga magkakasundo, kung pilitin mong i-reinstate, ay walang mangyayari kundi magbabangayan sila Walang mangyayari kung lagi na lang may irritation. So, ang sabi ng Supreme Court, parang happy compromise na lang na wag na silang magsama at babayaran na lang ng 1 month pay for every year of service instead of reinstatement. And this arrangement is win-win. Win-win. In other words, it is beneficial to both parties. Why? Because it would liberate the employee from an oppressive work environment. Can you imagine kung ikaw, hinabla mo yung kumpanya, tapos nanalo ka, tapos babalik ka sa kumpanya. Hindi kaya salubungin ka ng mga tingin na kung maaari lang na ang tingin ay makakapaso o ang tingin ay makakasugat. Siyempre, galit sa'yo yung management, hinabla mo eh. Tapos nanalo ka, ngayon babalik ka. So, to save you from that very difficult situation, bayaran ka na lang ng pera. At it also saved the employer, the company also. Kasi maiilang din ang kumpanya yun. Parang kung sa Tagalog pa, asiwa. Kung sa Bisaya pa, bakikaw. Yung bang hindi ka komportable. Pareho, kung ikaw halimbawa, nag-away na kayong mag-asawa, tapos nag-file na kayo ng annulment sa isa't isa, tapos dininay ng court yung annulment, magsasama pa ba kayo? Ganon din sa reinstatement. Ganon ang prinsipyo dyan, na hindi mo maaring turuan ang puso. Kasi madali lang yung sabing reinstatement, legal legal process yun eh. O tinanggal ka, illegal ang termination, balik ka. Pero in actual situation, and the Supreme Court is being practical, although wala naman yung sinasabi sa labor code itself, but this is somehow a product of jurisprudence, because the wisdom of the law lies in experience, no? Experience talaga, na sa totoong buhay mahirap pagsasamahin yung nag-aaway na, no? So strained relation, however, meron namang mga empleyado na hinablangan niya ang kumpanya, pero ayos naman sila pag nag-hearing, nag-uusap sila. Parang sport lang silang dalawa. Pero hindi pwedeng ang management ang magsasabi na hindi ko na siya i-reinstate kasi strained relation na. Dapat yung issue na yan should be ventilated before the labor arbiter during the execution stage. Kasi siyempre pag bago mag-issue ng writ of execution yung arbiter, ipatawag mo na yung dalawang party. O wala bang voluntary compliance, no? Kung ikaw arbiter ka, nung ako arbiter pa, ganun ang ginagawa ko eh. Dinesisyonan ko ng reinstatement, nag-appeal sa NLRC, ni-reverse ako ng NLRC. Pagdating sa Supreme Court, wala pang Court of Appeals doon eh. From NLRC, diretso pa sa Supreme Court kasi wala pa yung desisyon ng kaso ng St. Martin Funeral. So, at that time, from labor arbiter to NLRC, diretso sa Supreme Court. Ni-reverse ako ng NLRC pero in-upheld naman ako ng Supreme Court. Binalik na ngayon yung record ng kaso dito sa sala ko for purposes of execution. So, nagpa-file na yung complainant ng winning. The winning party has filed a motion for the issuance of a writ of execution. So, under the rules of the NLRC, before the arbiter issues a writ, the parties will be called to a conference for the purpose of determining na baka naman hindi na kailangang mag-issue pa ako ng writ kasi ikaw employer voluntarily naman magko-comply ka. So pag halimbawa after the conference it is found out na walang voluntary compliance, that is the time that I will issue the writ. But during the conference, I will determine whether there is really a strained relationship, because reinstatement can be substituted by separation pay. And another nuance about this is this. Suppose the order says reinstatement, but the employee, it's not the employer, it is the employee who says, "Sir, I don't want to be reinstated anymore." Kasi very tensyonado ako pag pumasok ako doon, stressful. So, if the employee manifests that he is no longer interested to be reinstated, in other words, he is waiving the principal remedy, which is reinstatement. And his waiver of reinstatement will give rise to the alternative remedy, which is separation pay in lieu of reinstatement. However, kung ang kabila, ang employer magsasabi, ayaw ko nang i-reinstate, hindi yan binding. Pag employee magsasabi, binding yun. Take note of that, ha? Pag employer magsabi, ayaw ko na yung tanggapin, despite that statement, the arbiter can still issue a writ ordering actual reinstatement. Pero pag ang empleyado na ang ayaw, remember, that is a right of the employee. So it is only the employee that can waive that right. It is not for the employer to choose. Pareho lang yan sa, if you remember, yung payroll reinstatement. Payroll reinstatement. Mabuti na yung lilinawin ko sa inyo lahat sa reinstatement. Pagka nanalo ang isang worker before the arbiter, the Herrera Law, Republic Act 6715, provides for reinstatement even pending appeal. Yan ang dapat tandaan nyo, ha, from 1974 to 1989, walang reinstatement pending appeal. It was, again, Senator Herrera who introduced that as an amendment to the Labor Code. At yan, Bisayan yan ang gumawa ng batas na yan. So, ang punto de vista ko ay ganito, kung umabot sa pagkakataon that it is the employer now that is obligated to reinstate, the choice of whether to be reinstated physically or only in the payroll is on the employer, not the employee. Di pwedeng sabihin ng employee, "Sir, ayaw ko nang mag-report doon, sa payroll na lang ko." No, that is not the choice of the employee. It is the choice of the employer. The employer has a choice. Pag sinabi ng employer, "I don't want to see your face anymore, I'll just deposit your salary through your bank account." No? But that is for the employer to decide, not the employee. So be careful about all this, ha? Now we will go to attorney's fees. Remember, ladies and gentlemen, that all the things that I am discussing tonight and even the other nights before, all these things are for the protection of the workers. Lahat na ito, protection of the workers. Attorney's fees, preference in case of bankruptcy, payment of separation pay. Book 3, all for the protection of the workers. Book 1, recruitment, all for the protection of the workers. Book 2, training, HR development, TESDA, all for the enhancement of the skills. So, the spirit of the law about attorney's fees is that the lawyer should not demand for higher than 10%. It's very clear. The purpose of the law is to protect the workers from the unethical and greedy lawyers. And this law limits the attorney's fees to 10%. Now, take note, this is only for recovery of wages. Ang limitation of 10% applies only for money claims. But for illegal dismissal, for unfair labor practice, for intra-union and inter-union, and even cases involving strikes, the law is silent as to the amount of attorney's fees. So what is being controlled by the state is money claim. Yung mag-claim ka ng overtime, holiday pay, night differential, 13-month pay, anything, service incentive leave with pay, anything, the amount that you receive should not be subjected to an attorney's fees higher than 10%. That is the letter and the spirit of the law. Now, in this case of Joselito Alba, the Supreme Court explained the concept of attorney's fees. There are two kinds of attorney's fees. Yung ordinary concept of attorney's fees is the amount that the client pays to his lawyer. That's attorney's fees. But on the other hand, there is an extraordinary concept of attorney's fees. And this is to be paid by the losing party to the winning party. So yung mga binabayad natin na per appearance, acceptance fee, that is the ordinary concept of attorney's fees. Pero yung ina-award sa decision, the amount awarded in the decision itself, is what the Supreme Court calls the extraordinary concept of attorney's fees. This was also discussed by Justice Marvick Leonen in the case involving Samir International Overseas Agency versus Joy Cabiles, explaining on the two concepts of attorney's fees. Now, this is an interesting question about a litigant who was represented by a public attorney, a lawyer. No? Does it mean that when you are represented by a POW lawyer, you are not entitled to attorney's fees? Because anyway, you did not pay the POW lawyer. Why should you be paid attorney's fees? Well, maybe you are not going to be paid the ordinary concept of attorney's fees, but the extraordinary one, you are entitled. And the Supreme Court said, quoting an earlier decision in a case decided by Justice Arturo Brion in Our House Realty Development Corporation versus Parian, the Supreme Court will disapprove the payment of attorney's fees. For instance, in this case involving a seafarer, he filed a case against the maritime company for disability benefits. But it was a premature filing because the company designated physician has not yet made a final determination as to the extent of his injury. And therefore, since the filing was premature, the court would cancel or delete any award given by the NLRC or the Court of Appeals. And this was decided by the former Chief Justice Maria Lourdes Sereno as Chief Justice. So there are instances when the workers are not entitled to attorney's fees, because attorney's fees are due only when there was an unlawful withholding of benefits. Since the filing was premature, there was no unlawful withholding of benefits, and therefore, logically, the employee claimant would not be entitled to attorney's fees. Because if you read Article 111, it's very clear. In cases of unlawful withholding. So there was no unlawful withholding because there was no entitlement yet. It was a premature filing. So the reason for giving attorney's fees did not exist in this case. See, attorney's fees mentioned here are extraordinary, the second one. No? Now, the Supreme Court also said that the 10% maximum limit, it's a maximum, does not mean that it cannot be lowered. So it's possible that the Supreme Court or the NLRC can give or can award an attorney's fees lower than 10%. What is not allowed is higher than 10%, but there is no prohibition to lower the amount of attorney's fees. In this case of Attorney Wilfredo Taganas, the Supreme Court reprimanded him and even disciplined him for receiving attorney's fees that is 50% of the total award. 50% of the total award. And that was considered as unethical, a violation of the Code of Professional Responsibility and also the canons of legal ethics. Principle number 18 is a series of prohibition. Prohibition like this one. In Article 112, the employer cannot interfere in the manner by which the employee will use his money. The employer cannot compel the employee to buy certain products from the employer. It is not an obligation on the part of the employee to buy products from the employer. To compel, therefore, an employee to buy from the employer would violate Article 112 because it would be tantamount to interference in the use of the wages. Then Article 114 prohibits deposits for losses and damages. Well, there are exceptions here in some industries where deducts or deposits are allowed, but that practice is subject to the implementing rules by the Secretary of Labor, including prohibited retaliatory deduction. Well, there are employers who retaliate against workers who file cases. When an employee goes to the DOLE to file a case of money claims, then as a retaliation, certain deductions are imposed by the company that would constitute another cause of action. Article 100, we have already discussed very thoroughly the principle of non-diminution with exceptions. If the diminution or withdrawal is bilaterally agreed, not imposed unilaterally. In the case of Insular Hotel Davao Waterfront, as well as in the case of Philippine Airlines, Gerardo Rivera versus Edgardo Espirito, there are exceptions to the rule. Another exception is when there was solutio indebiti, or payment that is not due to the employees, or an error in computation resulting to overpayment, that can be withdrawn because that would constitute rectification. But if it is allowed to linger and it has been repeated many times that it became a practice already, that practice can no longer be withdrawn because it would constitute already a diminution, which is a violation of Article 100 of the Labor Code. So what are the allowable deductions? I will enumerate that. And beyond that enumeration, that would constitute as an illegal deduction. Then prohibiting also withholding of kickbacks, like also related to that is deduction to ensure employment. The others, false reporting, is not important. So what are the allowable deductions? You can see on your screen, agency fee for unionized company. If you are an employee of a unionized company, you belong to the bargaining unit because your position is considered bargainable. You are not a managerial employee. You are not a confidential employee. You are a rank and file employee, and therefore your position belongs to the appropriate bargaining unit. But you are not a member of the union. You are an Iglesia Ni Cristo member. You have to pay agency fee if you accept the benefits arising from the collective bargaining agreement. So, the concept of membership in the union is different from membership in a bargaining unit. Because in one bargaining unit, say for instance, there are 1,000 members in a bargaining unit. There can be 5 unions in one bargaining unit because to form a union, you need only 20% of the total membership of the bargaining unit. So, if you do not belong to any of the 5 unions, you are a member of the bargaining unit, but you are not a member of the union. Now, since the benefits of the collective bargaining agreement will also redound to your own betterment and benefit, although you are not a member of the union, you derive a benefit out of the CBA, it's only just and reasonable that you have to pay agency fee. An agency fee does not need an individual written authorization. It's not like the union dues. The union dues must have a check-off agreement. In other words, in the collective bargaining agreement, there must be a provision that says that the employer is authorized to deduct a certain amount from the wage or salary of all employees who are members of the union, and to deliver the amount to the union, which is certified as the SEBA, or the sole and exclusive bargaining agent. But in terms of union dues, there is a need for an individual written authorization. Aside from the check-off agreement in the CBA, the worker individually and in writing. Because for the company to deduct without an individual written authorization is for that company to be guilty of illegal deduction. But in agency fee, there is no need for individual written authorization. The only requirement is, did you accept the benefit arising from the CBA? Because if you do accept, then you have to pay the amount of agency fee which is equal to the amount of the union dues given by the union members. And you are not a union member, but you also benefit from the collective bargaining agreement which was negotiated by the union. So you cannot be a free rider since you are part of the bargaining unit. Okay? And then itong mga PhilHealth, Pag-ibig, SSS, wala na yung ECC kasi ang ECC ang nagbabayad lang employer. The employee does not pay a counterpart amount of employees compensation contribution. Ang employer, dalawang bayaran niya, SSS plus ECC. Ang dalawang amount na ito, segregated, ay i-remit sa SSS, and the SSS will keep separate accounting for that account. The account for ECC is for death benefits, disability benefits, sickness benefits, hospitalization benefits. The SSS is for maternity benefits, retirement benefits, and also some hospitalization. So, the Office of the Secretary of Justice has issued an opinion that if you are an employee of the private sector, you are entitled to two benefits for one disability. You can collect from the SSS under the SSS fund and also collect from the Employees Compensation Fund, which is also under the custody of the SSS. But if you are an employee of the government and GSIS is your provider, you cannot collect twice. You collect only once. Now, another deduction is when your salary is subjected to attachment because you have a liability and the creditor filed a case against you and won, and to satisfy the judgment, since you have no other assets, your salary may be attached. And in the case of Rosario Gaa versus Court of Appeals, the Supreme Court has made a distinction between a salary and a wage. That a wage cannot be subject to attachment, but salaries can be subject to attachment. Withholding taxes, insurance premium, if you insure yourself and you execute an authority for deduction because the employer cannot deduct without this authority. If you want to get an insurance premium, you pay directly. But if you want the company to be a collector, then you have to authorize the company. Because for the company to deduct without authorization would be for the company to commit an illegal deduction. And there's a ground to file a case, and that would be money claims. Any indebtedness that you have, provided you authorize the company to deduct. For instance, you get yourself funeral plan. This is a pre-need plan or an educational plan for your children or grandchildren. And it is a group insurance plan. The person insured or covered by the policy may execute or should execute an authority. For management to deduct without such authority would be violation of this provision. So in the case of Bluer than Blue Company versus Esteban, the Supreme Court enumerated the requirements before deduction can be made. And these are in cases of losses or breakages. If by your negligence or your lack of foresight and lack of skill, you have caused damage to the property of your employer, the question is, can your employer deduct from your salary a certain amount every pay day so that the value of the things that thing that was damaged could be paid by you? There are requirements and protocols. First, that the employee is really proven to be the author of the proximate act that caused the damage. Hindi pwede yung buong department pababayarin mo, i-divide equally kasi you did not conduct a fact-finding investigation as to who among all the people in the department is guilty. Now, here, the employee concerned must be given an opportunity to be heard. This is due process. You cannot deprive him of his salary or a portion thereof without due process of law. That is depriving an employee of his property without due process of law. It's not just a violation of Book 3 of the Labor Code. It is also a transgression of the Bill of Rights, Article 3, Section 1 of the Constitution. So there must be a reasonable opportunity to explain. And if there is really a deduction to be made, the amount must be fair. Hindi yung arbitrary yung pagbigay ng cost, ng value ng isang bagay na nabasag o nawala, na hindi mo inimpute yung mga tinatawag na depreciation because that is an old property already. So over the years, the accountant would know how much, what percent is depreciated. And then when you deduct, you have to care for the worker that he will have enough take-home pay. Because if you deduct everything and he has zero take-home pay, that's not allowed. What is allowed is only 20% or 1/5 of his total salary. That is really to protect the employee. Again, this is protection. because that is the only means of livelihood, and you deduct everything that is not allowed under this law. So in this case of bluer than blue, the court said that there was an illegal deduction in this case because the employee was not given an opportunity to explain. In other words, there was no finding based on investigation that this employee is really the author of the proximate cause that brought about the damage. Without that, it's arbitrary. It is an arbitrary deprivation of the employee of his salary without due process. Now, itong isang school na ang pangalan ay Forest Hills, mga Seventh-day Adventist ba ito? Ang mga empleyado dinidika ng 10% kasi nasusulat daw sa banal na kasulatan na magbabayad ka na, magbibigay ka ng 10%. So ito, dineclare ito ng Supreme Court na null and void yung deduction because there is no written authorization. The authorization must be individual, not group authorization. And it must be in writing. And failing in this, therefore, led the Supreme Court, speaking through Justice Carpio Morales, to declare that there was indeed an illegal deduction. Again, in this case of PLDT, ito, maganda itong PLDT kasi ang empleyado, nangungutang siya sa ibang mga kumpanya. Halimbawa, nangungutang siya sa Camellia Homes ng lupa. Nangungutang siya ng mga appliances. Ngayon, nung nag-retire na or na redundancy itong empleyado na ito, idinidak ng PLDT sa kanyang redundancy pay yung mga utang niya. Ang sabi ng Supreme Court, that is another transaction. It should not be mixed with the employer-employer relationship. If the real estate company, which is separate and distinct from the employer company, if this company would like to collect, they have to file a civil case for collection. It should not be mixed with a labor case. Hindi maaari na bigla na lang ito, merong original na kaso dyan sa Nestle. Nestle, ang utang ng empleyado hindi sa ibang company, kundi sa Nestle mismo. Nangutang siya ng real estate loan. At noong nag-retire siya, dinidak yung entire amount. At nag-object siya. And the Supreme Court said, yes, tama ka, nag-object ka. Kasi you have the employer company as the creditor should file a case of collection against you. Dito, ang sinabi dito ng Supreme Court, pwede kayo mag-trade off kung ang inutangan mo ang PLDT. Ay, hindi na ang PLDT inutangan mo third person So, what is the personality of PLDT to deduct? PLDT is not the agent of the creditor companies or person. Hindi nga guarantor That's a separate transaction. So, nakalagay dito, the labor arbiter did not have jurisdiction because this is not a labor case. A collection of a sum of money is not a labor cost, it's a civil case. So what is the authority of the arbiter to include this in the deduction? Nothing. Ganon din dito, sa kaso na ito. So all these are prohibitions. The principle governing burdens of proof, I have already discussed this thoroughly. That pag ang claim ay non-payment of wage, ang burden of proof niyan ay ang employer. Pag ang claim ay 13-month pay, ang burden of proof niyan sa employer. Pero pag ang claim ay overtime pay, it is not in the normal course. Hindi naman lahat ng tao may overtime. So, the first burden is on the employee. Patunayan mo muna na ikaw ay nag-render ng overtime. At yung pag-render mo ng overtime ay with prior authority from the employer. Hindi yung ang empleyado lang ang magdesisyon na mag-overtime siya. Unauthorized yung overtime niya kasi he did not have the authority or the consent or the order coming from management. So once na mapatunayan ng empleyado that he had prior authority and he did render the overtime work, then the burden is now shifted to the employer to prove that payment was made. So there are two burdens. Pareho yan sa illegal dismissal Lagi nating sinasabi na sa illegal dismissal, ang may burden of proof ay ang employer. Pero lagi din sinasabi ng Supreme Court na bago magkaroon ng burden of proof ang employer, patunayan muna ng empleyado na tinanggal siya kasi napapagalitan lang siya. Hindi naman siya pinalayas Tapos magsusumbong kaagad ng illegal dismissal. Well, on the first hearing, you can always manifest if you have the counsel of the management. Your Honor, we asked for the dismissal of this case because we did not dismiss this complainant. In fact, we are giving him a memo to report for work immediately. Kaya pag sinabi ng employee na ayaw ko na pong bumalik. So, the decision comes from the employee. It is the employee who decides to leave the company. The company did not decide to terminate unless merong tinatawag na constructive dismissal, which is another issue. See? Ganda ng talakayan natin ngayong gabi. Huwag kayong mawala ng pag-asa na. Very basic naman yung dinidiscuss ni USEC. Alam ba ninyo na ang examiner ngayong sunod na bar ay very fond of the basic? Kaya huwag kayong mag-iisip ng mag-memorize kayo ng mga exception when you have not even mastered the basic. So, itong si Itom, na-discuss na natin ito na kung sino ang may burden of proof kasi nilabas ng management yung affidavit. Ito si Itom, dahil walang pinag-aralan ito, nung kumuha ng sahod niya, pinapirma siya ng papel na hindi naman niya naintindihan. Yung palang papel na yan is an affidavit na siya ay wala na siyang collectible from the company kasi everything has been paid. So when he filed the claims, inattach nila yon sa position paper nila, alleging that the employee himself has executed an affidavit that he has no more collectible from the company. Well, that affidavit, which is general in term, it did not even state how much did he receive, was not given any value by the Supreme Court.